Hello, everyone. Welcome to the arbitration channel. My name is Lauro Parenti, and that's going to be straight to the point. The idea here today is to discuss Fcpa and the key considerations about Brazilian companies. And I invited to coordinate this panel Professor Sergio Moro from Alvarez and Marsal. I'm going to give the floor to Professor Sergio Moro to introduce our other speakers. Good morning, Moro.
Good morning, Lauro. It's a great pleasure to be here. I want to say that we are grateful to be here. It's an opportunity to have an open discussion about the Fcpa and its consequences in countries like Brazil. And for that, we invited three experts to speak about the law. We in Brazil, we still have a lot of doubts about the extension of the Fcpa law and its influence in our practice. And also it will be great to hear from these United States experts how they work with, for example, internal investigation in corporations, in issues related with Fcpa compliance. And then let me introduce here, we have the team of experts. First, we have Chris Cestaro, who is a lawyer at WilmerHale. Chris worked as a federal prosecutor for more than 8 years. We focus on white-collar crime cases. Formerly, he worked also as a compliance counsel in a multinational oil service company. And Cestaro also served as the chief of the Foreign Corrupt Practice Act, Fcpa, at the DOJ. We also have here with us Maria Calvet, a lawyer at Ropes&Gray. Maria is also a former U.S. federal prosecutor. Also, she worked as a former in-house executive counsel of a company of the Fortune 500. She have already worked more than in internal investigation corporation in more than 40 different countries. And we also have here Steve Spiegelhalter. Steve is my partner at Alvarez and Marsal consulting company. Steve worked also as a federal prosecutor in the United States Department of Justice, Criminal Division, Fraud Section, and also with the Foreign Corrupt Practice Act unit. Steve also worked as a house counsel and compliance officer at a Fortune 40 technology company. And previous to join Alvarez Marsal, he led Ernst Young Forensic and Integrity Service practice in Washington. So, as you all can see, we have here a great team of experts to enlighten the Brazilian audience about the way they work with Fcpa. And this is a very valuable knowledge for us in Brazil nowadays. We are seeing the increasing of Fcpa cases all over the world and also involving Brazilian companies. Well, to start, let me make a question. I'm very comfortable today because I'll be only the moderator. I don't have to answer anything. So for me, it's like being in the I'm seeing a show of experts, and I'll learn a lot about it. Let's start with a question to Chris. Well, as our audience might be familiar, the Fcpa is a United States law that forbids corrupt payments to foreign officials. Chris, you were the chief of Fcpa division of United States DOJ. Could you give us a quick overview about the Fcpa And why should Brazilian companies care about our United States law, like the FCPA? What attracts United States jurisdiction in these cases over foreign companies?
Happy to do it, Sergio, and thank you, for the invitation to present with you all today. I really appreciate it. It's a privilege. So the FCPA is a complicated law, but I'll try to make it very simple. It has two primary parts. There is the anti-bribery provisions, which make it illegal to offer, promise, or pay a bribe to a foreign official in exchange in order to obtain or retain business. And the jurisdiction is very broad. It's really broken up into three primary parts. There are the issuer provisions. So the FCPA applies to issuers. Those are companies that are traded on United States Stock Exchange and file periodic reports with the Securities and Exchange Commission in the United States. And it also applies to officers, directors, employees, agents, and stockholders of issuers. The FCPA also applies to U.S. companies and U.S. individuals. So that's companies that have their principal place of business in the United States, or companies that are organized under the laws of the United States. It applies to those companies as well as officers, directors, employees, agents, and stockholders of those companies. And it applies to U.S. persons, which is U.S. residents, natives, and citizens. And then if you're anyone that doesn't fit into any of those categories, the FCPA in the entire world, the FCPA also applies to anyone who takes an act in furtherance of a bribery scheme while located in the United States. So you're on vacation with your family in the United States at Disney World or wherever else, and you send an email while located in the United States in furtherance of your bribery scheme, there's jurisdiction under the FCPA over you. And that's the anti-bribery provisions. Then there's also the accounting provisions, which only apply to issuers. So only companies that are traded on the United States stock exchanges and file periodic reports with the Securities and Exchange Commission and associated individuals. The FCPA requires that those companies maintain accurate books and records, as well as maintaining an adequate system of internal controls. And so, what we see is that there's very broad jurisdiction under the FCPA, and the U.S. prosecutors can also apply the money laundering statutes, the wire fraud statutes, other statutes to even get broader jurisdiction over corrupt conduct and corrupt bribery schemes. And as a result, when I was at the DOJ, we prosecuted a large number of cases over international companies, individuals located overseas, including a significant number of Brazil-related cases. I led and was involved in the prosecutions of Odebrecht and Braskem and J&F Investimentos. Recently, Jose Carlos Grubasic pled guilty. He was the former CEO of Braskem, which was an issuer company to FCPA-related crimes. And so if you're a Brazilian company or individual, and you're a Brazilian company and you have stock traded in the United States, or you have operations in the United States, or your employees or even your agents travel to the United States on occasion, then it makes a lot of sense to get wise to the FCPA and to take steps within your organization to mitigate any exposure you may have.
So, Chris, for this introduction about the FCPA and how it's important to Brazilian companies. So, in resume, if you want to make business in the United States or with the United States, you need to have an eye on the FCPA law. And this case are the number of FCPA investigation in case are increasing in the last years, at least my impression. Maria, you work at the DOJ and now you work as an attorney. We know that you have large experience in FCPA cases, and also that you work here in Latin America with some companies. Do you see difference between the approach taken by U.S. companies and Brazilian or Latin America companies regarding bribery incidents or Fcpa charges? What kind of advice regarding best practice you could give to us as an example for Brazilian companies when something happened, when an incident happened?
So again, I echo Chris's thanks, Sergio, for the opportunity to speak with all of you today. It's always a welcome pleasure. I think the question that you ask is a really nuanced one, because I haven't seen division along jurisdictional lines in terms of how companies approach internal or government-facing investigations. Rather, it's the level of sophistication of the company and the counsel. And why do I say that? Because as Chris pointed out, right, the Fcpa has tremendous global reach. As we'll talk about together, there are also local laws in almost every jurisdiction in Latin America, certainly in Brazil, and we've seen that robust enforcement over the course of the last number of years as well. The challenge really is whether the company that is facing those allegations or the internal whistleblower complaint or any number of other causes for concern is sophisticated enough and exposed enough to the intersectionality of all of these statutes and their responsibilities under them. That's really where I would say the rubber meets the road. So for example, if you have a multinationally operating company, even though they're based in Brazil, they're very likely to have a more robust compliance culture, a more robust compliance program, potentially than, let's say, a US-based company that is smaller or privately held. So I don't think it's easy to draw those lines purely along jurisdictional bases, but whenever, whether you're a company operating in Brazil or in any of the other jurisdictions where we have investigations in Latin America, I think the biggest takeaway for everybody listening today is that the rise of anti-corruption enforcement activity taken in tandem with the new laws throughout the region and the coordinated efforts between US and Latin American authorities create a heightened pressure, right, to be aware. So it's no longer just the Fcpa, it's no longer just folks like Chris, Steve, and I and our former colleagues who are handling these investigations. And that's been true for a very long time, including in a number of the cases that Chris mentioned. So sophisticated companies, as well as even local companies with international touch points, really have to adopt an international focus, right? They really need to think about the best ways to apply uniform standards to their anti-corruption mitigation strategies. And so the best way to do that is to create, and you have heard this, and many people have heard this before, so I'm not saying anything that is new or novel, but there's an emphasis on creating and maintaining a real culture of compliance, right? With the tone set at the top, embraced at every level of the company, and what does that mean? It means that there's an expectation of compliant business practices and ethical business practices, and that any failure to adhere to that expectation is going to get an immediate response, right? And the timeliness of the response is really important as well. I think another key way to try to mitigate against this risk, and we'll talk more about how that risk can kind of manifest itself, is to have a company that supports the internal gatekeepers. Over the many years that I've worked in Latin America, one of the challenges that I have certainly witnessed and observed is that those people within a company who are tasked with managing compliance programs, implementing those programs, training personnel, detecting red flags, are sometimes really siloed, right? And they don't have the infrastructure to support their work. And so making sure that resources are available, that the response can be adequate is incredibly important. And then streamlining how that response can be escalated. So if I'm an employee at a Brazilian company and I'm aware of a potential wrongdoing, or I have concern about a potential wrongdoing, where do I turn, right? And how is that really clearly communicated so that the company can then respond? And then most notably, I think particularly, and this could be a panel in and of itself, but particularly in these very challenging times with respect to the pandemic, ensuring that you have connectivity between your various personnel as they mitigate and manage and navigate risk. You know, many of us have talked about the pandemic creating a bit of a perfect storm from an internal compliance and investigations perspective, because you have people operating in isolation under tremendous economic pressure at a time where there is a really rampant need for government resources. And so that creates a real risk of graft and corruption. And so making sure that those policies and procedures and training and connectivity within your organization aren't compromised as much as you possibly can, I think is a really important step for mitigating risk.
Thank you, Maria. We are seeing, as I said, the increase of Fcpa investigation last years in Brazil, and we saw also this changing of our culture, of the corporate culture, companies developing each day more strong compliance programs. But I still I believe we have a lot to learn yet. Of course, there are different levels of complexity of Brazilian companies, as you said. Steve, you worked a long time as a prosecutor, and then you worked a long time at the private sector, assisting companies with internal corporate investigations. Based on your experience, what are the main differences between an official investigation and an internal corporate investigation? What are the advantages and disadvantages, tools, or practice of each one? What is better, to be a prosecutor or a private investigation? What is easier?
That's a question with a lot of levels, but I'll keep it at the purely professional level. So thanks for having me. Like Chris and Maria said, this is a great opportunity to talk with two of my colleagues and friends, and I'm really glad that we got a chance to do this. Look, I think it's a great question, because I think that a lot of people don't understand the power that the Department of Justice and the Securities Exchange Commission have, especially when working with the FBI in the United States and with foreign prosecutors. So let me start with the official investigation. There are a number of things that prosecutors can do that we just can't do in the private sector. The first and foremost is as a prosecutor, I had subpoena power. I could ask for almost anything I wanted. I could ask for any person. I could ask for any document. I could ask for any data. So that far and away is the biggest tool that I had as a prosecutor that I no longer have. And if a company refused or failed to give me what I wanted, they could be prosecuted for that. So it was a lot of authority. Secondly, when people came and met with me, if they lied to me, they could be charged with a crime, and that's actually what happens a lot when the U.S. government is investigating crime, is that the underlying crime sometimes is sort of hard to prove, but it's quite easy to prove that someone lied to me. And so that's 18 U.S.C. 1001 in the United States is a charge that gets brought a lot. I think the other thing that as an official I could do is I could look more broadly at more companies, and I could work more broadly with more partners. So looking at more companies, I very rarely was investigating just one company and asking for data from only one company. I was generally looking at companies that were in the same business lines. They could have been competitors, or they could have been co-conspirators. And so I was getting data and information from various places, and I could compare what I got from one company versus what I got from another and really get a pretty good picture of what was happening. So that was a lot of authority. And then working with more partners, I could pick up the phone and call prosecutors in Switzerland or the UK or West Africa, wherever I happened to be working at the time. I know Chris could pick up the phone and call the Brazilian prosecutors quite easily. I know Maria, same thing, had some big sprawling cases where she developed some good relationships, and those relationships really pay off if you're a prosecutor. So on the flip side, there are also advantages. Look, lacking all of that, especially lacking subpoena power and sort of the coercive power of ensuring that someone doesn't, or at least minimizing the chance that they're lying to you, is something you lack in an internal investigation. And so that is something that comes up when we're talking to prosecutors now. When I'm in private practice, a lot of times one of our responses is, we don't have subpoena power, right? If one of our business partners did something, it is hard for us to tell sometimes, and that is probably the biggest disadvantage of being in-house. I think the advantages of doing an internal investigation are that you become much more intimately familiar with the business. So you understand the products, you understand the personalities. And as a prosecutor, because I had 10 or 15 cases at a time, that is not something I generally could do. So I didn't understand fully the companies that I was working across the table from. And if I had understood that, I think I would have been I could have figured out more easily what was actually happening in a company. So I think that's something I love about an internal investigation. And I think that when we work with partners in-house, when we work with general counsel, we work with the heads of internal audit or chief compliance officers, their intimate familiarity with the business is a huge advantage to them that you just don't get. You get unfettered access to data. So one thing that we do in my line of business at A&M is we'll typically come in as part of an investigation, and we'll take the entire accounting system, take a copy of it, just to be clear, we're not interfering with the business. We'll take a copy of the entire accounting system and some other systems that might be relevant, customer management systems or supplier relationship systems. And we can really get a very complete picture of what happened using those systems because of the way transactions are recorded, who the company was doing business with, who approved a particular transactions, why the company paid money out. My ability to come in and take those systems entirely and run data analytics against them is a gigantic advantage in figuring out what happened. I much prefer having that ability. If I were ever back at the Department of Justice, I would probably hire people like me to do the flip side, because the department just doesn't have the resources to do that. So unbelievably, I think one thing that people who are used to being chief compliance officers or general counsel would be shocked by is that the company has much better resources available to it than the department does, or than the Securities and Exchange Commission does, just because they have, internally, you got to worry about one company, which could be sprawling and complex. But if you're at the SEC or DOJ, you're worried about hundreds of companies at the same time. So they just didn't have the resources that we have on the private side. So I think those are the main differences. Maybe Chris and Maria would pipe in if I missed something major.
Thank you, Steve. It's very interesting. I remember my time as also as a judge. You have several cases that you need to deal at the same time, and usually public sector does not have all the resources that the private sector has. Of course, then in an internal investigation, you need full cooperation from your client to get the results. I believe this is very important.
Yeah, the only other thing, I'm sorry, the only other thing I'd add, I agree with everything you said, Steve. I struggle and have struggled for many years, having left the government, at where my evidentiary trail ends, right? There's only so far I can go in an internal investigation on behalf of the company before I can't know the rest of the story, because I don't have access to the documents or the bank account records or third-party emails, for example. The other thing that I think is a huge challenge in the private sector is assessing the risk of what you've found when you don't have the visibility into those ongoing government investigations or the government's priorities. And so we all have that experience that we try to leverage. We can read and analyze the current cases and the current trends, but it's very difficult when you have a client who might be on the fence about voluntary disclosure, or might be on the fence about whether or not this rises to the level of an investigation that needs to be, and this is, again, an entirely separate panel, but rises to the level of something that needs to be disclosed, and really helping to frame the facts of your current investigation within that broader context and really help a client figure out what the right decision is. I think it's just tough when you don't see what we once were able to see.
Thank you. I have some questions about this, the obligation to disclose or not. I'll get them really soon. This is something that we are very curious here in Brazil, how this works, United States. But first, let me make a question to Chris about international cooperation. We have seen the increase of the use of this tool also. It's an international trend. But especially during the car wash operation here in Brazil, we saw a great increase of this use of these tools, for example, the MLAT. So, Chris, how do you describe the level of international coordination in FCPA investigation and settlements, particularly the relationship between the United States and Brazilian authorities? What kind of tools the United States and foreign authorities have to cooperate between themselves?
Yeah, so these are FCPA cases are foreign bribery cases, right? And that means that there's multiple jurisdictions, often outside of the United States, that are implicated in any investigation. And so as Steve and Maria were touching on, U.S. prosecutors have a lot of authority and tools in order to get evidence, but that a lot of those tools are applicable domestically within the U.S. And when the evidence is overseas, then often U.S. prosecutors are relying on foreign prosecutors to help them get that evidence. And so having strong relationships with foreign authorities, if you're a U.S. prosecutor focusing on an FCPA case, is just absolutely critical. And, when I was running the unit, we spent a lot of effort in trying to develop those relationships, deepen those relationships, expand those relationships. And I know, firsthand that absolutely continues today. And it just makes so much sense if you're a prosecutor, that leads to better evidence more swiftly. It leads to more leads for cases. And it's just a critical component of what the FCPA unit needs to do in order to move their cases. Regarding Brazil specifically, which you asked about, that relationship, I would say, is one of the strongest that there has been from the FCPA unit with foreign authorities. The prosecutors in Brazil, the federal police, the CGU, all of the enforcement authorities in Brazil, they brought an astounding number of cases and held just an unbelievable number of companies and individuals accountable for corrupt conduct. And to be able to be involved in assisting those prosecutors from the U.S. and providing evidence and information that helped them advance their cases, as well as to get evidence from them in advancing U.S.-based cases, was really, while I was there, a true honor, and something that I think is really, really important. And so I think that relationship remains. I know that relationship remains very strong today. And I know that there's a lot of evidence sharing that goes on, a lot of lead sharing that goes on. And the way that happens, you asked about the MLAT process, is really in two primary ways. There's formal sharing and there's informal sharing. And what U.S. prosecutors want is to get to a place where there's enough trust and enough of a relationship with the foreign authorities to do informal sharing. Because what that means is you're getting things in real time, very swiftly. It can be as simple as picking up a phone call and asking the foreign prosecutor about a question to get information about your case, or getting an email where they're attaching the key emails in the case so that you can very quickly bring those emails to go confront the person involved in the crime or to try to get a search warrant in the U.S. And that can happen in real time. Whereas if you're working in a formal land, then what that means is you're going through the Mutual Legal Assistance Treaty process, which is the formal process typically where the U.S. prosecutors are creating writing a document that lays out the case, that asks for whatever specific evidence that they need in the case. They're submitting it to the U.S. Central Authority, who then submits it to the foreign country's central authority, and then it gets assigned in the foreign country to a prosecutor who may have no interest whatsoever, who likely has no interest whatsoever in the U.S. case. And it's just one of many, many things that prosecutor has to do. And it may take years in certain instances for that to get acted upon. And so the formal process can be very slow, but unless there are relationships developed where you can call the prosecutor who has received that MLAT, or you can direct that MLAT to a prosecutor who has a parallel investigation, and now they're incentivized to speed up and get those records more quickly to the U.S. prosecutors. And, you know, there may be situations where you need to go through the formal process in order to get certified records to admit in trial. And there certainly is reciprocity where foreign authorities are seeking records through the formal process as well, because they need them for their processes, as well as you may need to go through the formal process in order to set up things like interviews, which are often done. But throughout it all, the key is, you know, as those relationships develop, as the trust is strengthened, everything moves more efficiently and more swiftly if you're a prosecutor. And so, you know, there's a lot of focus on developing and expanding those relationships.
Thank you. Thank you, Chris. Just to be clear, because here there is a lot of curiosity and doubts about that. So you can have international cooperation without the use of the MLAT proceeding, right?
Absolutely correct. And that goes on between the United States and many different countries around the world.
Okay. Thank you very much. And maybe the best way to have this is that when you have a case, for example, you need to open a case in the United States to have a search and seizure, and this could be used also in Brazil and vice versa, things like that.
Absolutely correct. That happens. And one key point to note is the United States, you know, only extremely rarely, almost never, enters into joint investigations with foreign authorities. You know, many different countries, they'll do that where one country will have a joint investigation with another country into certain conduct. U.S. prosecutors don't do that. And so they're always working in parallel with the foreign authorities. But like you said, that information evidence from a search warrant, that can be shared very swiftly and informally, other evidence as well.
Okay, thank you. Well, one question that appears a lot here in Brazil related with internal corporate investigation. Maria, could you tell us a little about your practice in the United States? For example, by United States law, in an internal corporate investigation, does the employee have the privilege against self-incrimination, and could he refuse to answer questions in an internal corporate investigations? If he refuses, are there consequences? Could he be dismissed, for example? The lawyer, when the lawyer is conducting the interview, does he need to make any kind of warnings to the employee, for example, Miranda warnings or things like that?
Yeah, thank you. It's a complex question that you've asked. The short answer is no, an employee does not have the right against self-incrimination in an internal investigations context. But yes, they can refuse to answer questions. And yes, there are potential consequences for that. But let me break that down in a little bit more detail. Of course, in the US, there is a privilege against self-incrimination. That is a constitutional right that is set forth in the Fifth Amendment. It protects individuals from being compelled by government officials to provide incriminating statements or testify against their interest. And that's where the real rubber meets the road for purposes of internal investigations, right? That Fifth Amendment protection would apply, for example, if Chris or Steve or I were still prosecutors, then yes, right, that individual is protected against the right, against self-incrimination. That does not typically apply in the context of an internal investigation where you are an at-will employee of a company. However, there are, an employee could choose not to answer questions. And as the investigating lawyer, it's a real delicate balance that we have to try to strike. The first most important thing that an investigations lawyer does is issue, it's not the Miranda warning, because that's really in the context of a government actor. It's called an upjohn warning. And that warning essentially informs the employee that the investigations lawyer, so in this instance, me, represents the company, and that I don't represent any individual, and that any information that I get as a part of that internal investigation, that information belongs to the company, and ultimately the company can decide what to do with that information. And so as I try to conduct internal investigations, really focus on ensuring that people understand the distinction with my role. However, an employee can choose to refuse to answer questions, and generally, those decisions, can bring, and under, most U.S. companies' rules and at-will employment contracts, failure to cooperate with an internal investigation can implicate disciplinary measures by the employer, an interruption of benefits, termination with or without cause. Now, I will just pause and say that that is true under U.S. law for U.S. employees of a U.S.-based company. Any global internal investigation definitely needs to account for implications under local law. So, for example, in various jurisdictions, there might be labor and employment rights that employees have if they are employees of that company in that country under those local laws. And so, as much as I focus principally in my remarks here and in the way that I conduct internal investigations on the U.S. laws and standards that apply to my internal investigations, I do always consult with local counsel so that I'm aware of any consequences that might exist for employees under local law as well. Similarly, we'll talk about this a little bit later on, right? The work product that I generate during the course of an internal investigation is afforded certain protections under U.S. law too. And so again, when there are certain circumstances where the employee's right can be triggered. So if the corporation is compelled and the employee's actions are attributable, and then again, this gets a little bit more nuanced, then certainly that might trigger that protection as well. But generally speaking, when we're talking about a purely internal investigation under U.S. law, that Fifth Amendment protection does not apply. But be happy to have Steve or Chris also offer their thoughts and approaches on how they deliver the upjohn warning and how they handle these investigation in context. Again, the upjohn warning has a certain number of elements that I've tried to capture for you. One of the final ones, which I think is the most difficult, which I failed to mention. So first, to say that you represent the company. Second, to say that that conversation is protected by a privilege, but that privilege belongs to the company and not to the individual. And the third one, which I think is the hardest, is to remind the employee that they have an obligation to protect the confidentiality of that conversation. And that is virtually impossible to do because almost universally when people leave the room, that confidentiality reminder is easily forgotten. And so as you're conducting internal investigations, it's incredibly challenging to try to preserve that confidentiality. But open it up to Steve or Chris for their thoughts as well.
Well, it was a complex question, but I made it to the right person. We got a great explanation about this issue John is a reference of a Supreme Court case, right?
It is. It is. So the communications, so attorney-client privilege applies when communications concern matters, and this is quoting from the case, matters within the scope of the employee's corporate duties. The employees themselves were sufficiently aware that they were being questioned in order that the corporation could obtain legal advice. So that's why it's so important to inform the employee what your role is, right? So my job is to give the company legal advice, and whatever we're talking about relates to your employment and the work that you do for that company. And so that's why I'm asking you these questions in this privileged context.
Thank you very much.
Sure.
Now a question for Steve. Steve, we saw a lot of big companies building strong compliance programs, but we know that there is no such a thing as a perfect compliance program that will avoid any kind of incident. So the question is related to this imperfection, because some companies are worried that, well, I'll do everything to avoid any kind of trouble, but when something happens, I will be penalized anyway. So the point is, considering your experience as a prosecutor and also now at the private sector, is the company always responsible for its employee acts in cases regarding fraud or bribery? What efforts companies can make to avoid liability for their employees' criminal conduct? Could you give us some example? I know that you work in a case, in an important case involving a bank institution, a case that this kind of question were considered.
Sure. I think that the easy answer is, as a matter of law in the United States, because of a doctrine called respondeat superior, the company is essentially always liable for the activities of its employees. I mean, you could debate it. The test requires it be in the scope of their employment, and the way that normally works out is if the activity of the employee is at least in part to benefit the company will be responsible for the activities of its employees. So I don't remember very many cases where we were actually debating whether the company was liable for the activities of their employees. The company is essentially always going to be liable. And I think that even more broadly, I think an important point is for public companies are always responsible for their internal controls. So even if you had an employee that was acting solely for his or her own, pecuniary gain, they were defrauding the company, whatever it might be, the company should have internal controls that are sufficient to ensure that kind of activity doesn't happen anyway. So there are, and then you have potentially civil liability for failing to, or criminal if it's willful, for failing to have those internal controls in place. That said, there is always a dialogue with the prosecutors about whether this employee was really acting for the company's benefit, whether the employee was rogue, as every defense counsel has always, when I was a prosecutor, said that it was a single rogue employee. There's always a conversation about whether this employee is out acting on his own or her own, and really not for the company. And then there's a soft consideration that I think has gotten much better in recent years, where prosecutors do take into account the quality of the compliance program when determining what the penalty will be. There are various, and we don't need to get too deeply into this. There's the form of the resolution, whether it's a non-prosecution or a deferred prosecution or a guilty plea. There's the size of the penalty or fine, and those really do take into account, much better now than when I was a prosecutor, frankly, they take into account the quality of the compliance program. And so I think that the government has done a lot to incentivize companies to invest in compliance. I actually think that really the government should do more in this space, but I think that's a continuing dialogue. There is a case where I was a prosecutor. I investigated a managing director of Morgan Stanley who was operating in Asia, and he was a high up officer of Morgan Stanley. He engaged in corruption, and we decided that the bank had sufficient internal controls in place that really the bank should not be held criminally liable, and ultimately wasn't held civilly liable by the SEC either for the activities of this employee. The controls in place, largely because it was a financial institution, really were quite impressive, and the bank had done a very, very good job of documenting exactly what the bank had done to avoid this kind of activity. And I think that's one place where a lot of clients, a lot of companies sort of fall down, is in documenting everything. The bank kept internal records that were really granular about how often this employee had been counseled not to do exactly what he did, and how many controls he had to dupe, and how he was able to do it. And the scheme was incredibly sophisticated. The employee was in league with a Canadian attorney that was known to be the actual attorney for an SOE for a state-owned entity in China, and was also in league with the official, who was a decently high official in the Shanghai government in China. And so, it was really a one-off case, I think, but it's one where I think it merits every company going back and looking at it again to determine how best to build a record so that if something happens, and Judge Moro, like you said, something always happens. It doesn't matter how good the compliance program is. Something will always happen because humans are humans. As was often said at a company I worked with once, any city in the world with 400,000 people will have a jail. So if we're a company with 400,000 people, it's going to be the same. But there is great value, I think, in putting resources into the compliance program, and especially really keeping track of how good that program was in real time.
So that's a case where the company it did all efforts to build a strong compliance program, and then the company was able to avoid criminal liability, right?
That's exactly right. Criminal and civil. The company did not pay any fines in any setting.
Okay, thank you. I believe that is an important lesson for all big companies who want to do the right thing, to show that yes, it's possible to avoid this kind of liability, building strong compliance programs. Now a question to Chris. That's about the point over a disclosure. Chris, if a company conducts an internal corporate investigation and discovered that an employee committed a crime, bribery, for example, does it have the obligation to self-report as a general rule to the United States authorities? And if this happens in Brazil, in a company who, for example, have stock exchange in New York, and a question also related to this point. If a company is going to pursue a settlement with Brazilian authorities for transnational corruption, does it have an obligation to self-report to United States authorities? That's it.
So generally speaking, under U.S. law, there's no obligation for a company to self-report to U.S. authorities. There may be certain circumstances, like a financial institution may be required to report suspicious activity in customer accounts or in transactions to U.S. authorities. Or if it's an issuer company, a publicly traded company that files reports with the SEC, they may be required to publicly disclose certain conduct in certain specific issues, at certain specific instances. But generally, there's no requirement, and there's no requirement to report to the U.S. authorities, and that's exactly why the DOJ created the corporate enforcement policy, which is a policy geared at trying to incentivize companies to self-report misconduct. DOJ created a program to try to, incentivize companies, give companies certain benefits for self-reporting, in part because they're not required to do so. And what that program outlines is that, in generally speaking, if a company voluntarily self-reports misconduct to DOJ that's related to bribery, if it fully cooperates with the government's investigation, if it fully remediates the misconduct, then there's a presumption that, absent aggravating circumstances, that the DOJ will simply close that case against the company. The DOJ will not require the company to enter into any form of those resolutions that Steve talked about, a guilty plea or a deferred prosecution agreement or a non-prosecution agreement. The DOJ will simply close the case. They'll make it public that they're closing the case and make it public on their website. And the company will be required to pay the illegal gains of the bribery scheme. So they'll have to disgorge any illegal profits that the company earned, but the company will not be required to pay any penalties, and the company will not have to have a multi-year agreement with the Department of Justice where they're required to take on certain obligations, or they're required to accept kind of criminal responsibility for the conduct. And so that's the corporate enforcement policy and the incentive to companies to voluntarily self-disclose. I would say if you're in a situation where you're trying to decide whether or not it makes sense to disclose to the Department of Justice misconduct, I really implore you to get experienced outside counsel with, who understands how the DOJ thinks about cases. It is not it is definitely not always the right decision to self-disclose misconduct to the department. That's something that really needs to be considered on a case-by-case basis. You also mentioned, if a Brazilian company is going to have a resolution with Brazil, should it disclose to the United States the misconduct? Again, I think that is very fact-specific. It depends in part, on whether there's jurisdiction in the United States over the case. It depends on a number of factors. One thing I will say is, if you're going to enter into a resolution with a Brazilian authorities over bribery misconduct, then that's going to be public. And in all likelihood, the DOJ is going to find out about that. So if you believe that there is potential U.S. jurisdiction, or you want closure with the United States, then certainly you should consider how to address the U.S. authorities. It may not mean disclosing to the U.S. authorities, but it may mean disclosing to the U.S. authorities. And if you are seeking closure with the Department of Justice in a case, then disclosing early is going to be better than disclosing late, because there's a policy called the anti-piling on policy, where the DOJ is required to try to avoid duplicative penalties. So if you're paying penalties in Brazil for a corruption scheme, and the DOJ has a parallel investigation and is aware of the misconduct at the same time and is investigating at the same time, then the DOJ will look to coordinate with the Brazilian prosecutors in order to avoid duplicate penalties, so that you're not paying, 100% of the penalties in Brazil and 100% of the penalties in the US and paying twice, that there's some kind of crediting coordination that mitigates the penalties. So, I think the key takeaway is that the landscape, as we've described, is international. There's multiple authorities to consider in all of these cases. And it's just, as it gets more international, it gets more complicated. And so I think it's just critical to engage counsel early and to think through all of the different jurisdictions and how best to approach each jurisdiction. That may be disclosing, it may be not disclosing, but you absolutely need to have that consideration and think through that in advance of reaching a resolution in any country.
Thank you, Chris. And Chris, this is what you said is related with the DOJ piling on policy for global settlements?
Yeah, so that policy says that if the DOJ is investigating a case and there is a resolution with another authority, then the DOJ should seek, where available, to avoid duplicative penalties. And so what the DOJ will do, you see this in many of the Brazilian cases it's happened. For example, the Odebrecht case, there was a coordinated resolution where Brazil entered into an agreement with the company at the same time as the Department of Justice and at the same time as Switzerland. And the DOJ penalty was not duplicative of the Brazilian penalty. What the DOJ did was it credited, Odebrecht would have had to pay over $2 billion in the United States, but it credited what Odebrecht paid in Brazil so that Odebrecht only had to pay 10% of the penalty in the United States. And that is something that you're seeing in increasing frequency in cases, and you've seen in more than a dozen cases since 2016.
Thank you, Chris. Maria, a question about another complex question about the attorney privilege. How the attorney privilege applies to internal corporate investigation in the United States? In which circumstances the attorney-client privilege protects the results of the investigations and the communications with company employees? Are there protections regarding the work of other kind of experts, for example, a consulting company? Could you give us an explanation about the work product protection? You also mentioned it in a former answer, but could you develop it more?
Sure, happily. So one of the biggest challenges, I think, in conducting an internal investigation is navigating this very question, because it's an incredibly complex one to answer, particularly in cross-border investigations. So protecting privilege in internal investigations is a really critical step, and it's necessary to avoid disclosure of sensitive information. So even if at some point in the future, to Chris's earlier point, the company makes a decision about voluntary disclosure or cooperation with a government authority, the information that their lawyers obtained and the communications with those lawyers and the work product that those lawyers generated is not part of the information that should be disclosed to authorities. But navigating that from the very beginning, the very early steps, is really important to protecting the investigation. So in the US, there are two grounds for protecting documents and communications from disclosure. So one is the attorney-client privilege, and they're related, right? And the other is the work product doctrine. So at a very high level, for a communication to qualify for the attorney-client privilege, it has to be undertaken in confidence between an attorney and her client for the purpose of receiving or providing legal assistance. It is not enough to just copy a lawyer on every communication to make it a privileged communication. On the contrary, it has to be in the context of obtaining that advice from the lawyer. It is the client that holds the privilege, so the client is the one who can assert that. The privilege belongs to corporations and to individuals. Again, with the caveat that I mentioned earlier when we were talking about Upjohn warnings, where in that context, the client is the company, not the individual employee. There are exceptions, like with any legal rule. There are more exceptions sometimes than the rule itself to the attorney-client privilege. The most common of those is the exception in an investigative context, which is the crime-fraud exception. And crime-fraud rarely would apply in the context of what we're talking about, because it's only where the client is seeking advice from an attorney to help them commit crime or fraud, which obviously we're not allowed to do under the ethical rules. But if the client has already, right, if the crime has already occurred and they're seeking advice on how to investigate internally, how to engage with the government, how to respond to a subpoena, all of that communication is protected by privilege under US law. There's a wide variety of materials that are generated during an internal investigation that are protected by that privilege. So that could be presentations that the lawyers deliver to the client. That can be emails, communication, interview memoranda between the company compliance or in-house counsel and the outside counsel. So conversations, to your question about third parties, like a consultant or some other third party. So conversations with third parties may not be protected by the attorney-client privilege unless that third party is working at the direction of the lawyer. So for example, if I at Ropes&Gray were to hire Alvarez to work on a matter with me, then on behalf of our client, then that work of the consultant would be done at the direction of outside US counsel. And so therefore it also enjoys the same privilege. Again, very important to be clear that that role is an investigative role and not, for example, like an auditing function that is part of a routine financial audit, because that's separate and apart from the work of the lawyers or the legal team or people working at the direction of those lawyers. The work product doctrine protects documents. Those don't have to be communication. They can be notes. They can be information assembled by the attorneys or by anyone that the attorneys instruct or supervise in anticipation of litigation. And there's the qualifier that I will just raise there. That includes any research, compilation of background materials, written statements, memos, factual chronologies, and any of our mental impressions. There, any documents that might be prepared by non-legal personnel, like consulting firms or financial professionals. I often joke that I didn't study accounting and don't have a solid finance background, so I always like to bring that expertise into my investigations, but they have to be working at my direction in anticipation of evaluating a potential legal risk. So as I mentioned at the very beginning, it's really important to think about and pay special attention to cross-border investigations. So for example, in the US, in-house lawyers. So when I was an in-house lawyer and Steve was as well, and Chris worked in-house, if we're working in a purely legal capacity in the US, our work is also protected by this privilege. That is not true in many other jurisdictions where we operate and where multinational companies operate, including in Brazil. And so there, it's important to ensure that you're taking the necessary steps to have the work of an internal investigation be led by and directed by outside counsel, because in-house counsel in the company under the local law may not be afforded the same level of protection. And even in the US, where privilege rules are going to be evaluated. So let's assume, for example, that the company decided to cooperate with the government, decided to voluntarily disclose, and decided to produce documents as part of that cooperation, but inadvertently produced documents that the company now wants to say are privileged. There would be an analysis conducted about whether or not those documents are privileged, and the way that you treated them from the very beginning and the way that the work was conducted and at whose direction will matter, as will local law, right? There will be an interpretation under local law. So the best practice to avoid a waiver of privilege in multi-jurisdictional cases, particularly in Brazil, includes some of the things that I'm sure you have seen folks like Chris and Steve and I and others do, which is labeling sensitive documents, privileged and confidential. And again, just stamping it with that label also isn't enough, right? You have to really be engaging outside counsel for communications between certainly with the company and third parties, like the consultants or the forensic accountants that we've talked about, really focusing on ensuring that those communications center around legal issues and not around commercial issues, and just segregating that work product from any other work product that might not be equally protected.
Thank you, Maria. I really enjoyed the part of your explanation when you said about Ropes&Gray and ours, Marsal, doing a case together. It was a great explanation, but that was the best part. Maybe there's an idea here. Steve, a question for you. When it came to anti-bribery compliance programs, what are some of the biggest compliance program breakdowns or weakness you've seen for multinational companies subject to the FCPA? Have you seen in your experience important difference between corporate compliance programs across different jurisdictions? For example, between the United States, Europe, and Brazil?
Thanks. Look, I think you could talk all day about where compliance programs go wrong, and it's very easy for a compliance program to go wrong. I obviously worked in-house in a compliance program and then evaluated them at DOJ, and now I work in compliance all the time, either as a standalone engagement where we come in and we look at a compliance program and try to fix it proactively, which is obviously a very good idea, or after there's been a compliance failure, we always have to take a look at exactly what happened. I think you can bucket the failures into a number of areas. I think the first and foremost, there's a failure to assess risk, and this is something that DOJ and SEC have talked about for years and years now. But it is hard to convince a company that has all kinds of competing priorities to step back and really do a holistic look at where the company's risk lies. And I think there's also a failure of imagination about where risk lies. So if you think about a lot of companies that sell, technology, for instance, the first step in the risk chain there is how did you price your product? And nobody gets that far back, right? A company will look at something like, did we sell through an intermediary? Did our sales guys entertain people in a way that they shouldn't have? And those are tried and true ways of looking at what's happening. But if you are a technology company or a commodity sales company, whatever it might be, how did you price your product? Were your margins unusually low on whatever sale you just made? And why is that? So we've done projects recently talking to companies about their deal desk. So getting all the way back to that first question about how they price their product. And if you were sort of to index, we're in a risky jurisdiction, we're selling to an SOE, we have an intermediary involved, and our margin is low, then why all of that? And a failure to transmit that information in real time to a compliance department, so the compliance department can take a look. There are some companies that have gotten pretty forward-leaning in this area, but a lot of companies sort of fail to think creatively about it. I think the second thing is under-resourcing the compliance program. This is something that DOJ, when DOJ hired the compliance consultant, back in the day, one of the first things she said was, do compliance personnel have the same opportunity for advancement? Are they paid in the same way as personnel elsewhere in the company? Do people move from the business into compliance and back out? And those are all really good questions. Compliance in some companies is sort of a backwater. I've literally seen it as a place to stow underperforming employees. I think that's much more rare than it used to be. And the compliance officers we work with now are really impressive. But I think that has been a real change from years past. Really creative companies, some of them will have their executives from other areas in the company do a turn in compliance, literally become compliance officers for a period to figure out what that's all about, and to really make sure that they understand how important compliance is. And I think the other thing, if putting myself back in the shoes of DOJ and SEC, and something that they've preached upon a lot recently is, your company uses data to sell your products all day long. You slice and dice your data, or you sell your data as it is, but your compliance personnel don't have access to all the key data. And if you were to really think about where fraud happens or where corruption happens, it leaves breadcrumbs in your data that if you're looking for them, you'll be able to find them and to follow the trail. And I think that companies still fail to do that a lot. There's a failure to revise controls. So every time an internal audit report comes back, and every time there's an internal investigation, you have to, you should actually ask this question somewhat close to the beginning, but certainly by the time you get to the end, how did this happen, right? How did money leave our company? And why were our controls in such a state that it was possible for that to happen? And you have to fix those. I was always amazed when I got to the end of a multi-year investigation when I was at the Department of Justice, and I would ask the lawyers, I would say, okay, if today X, Y, and Z happened, and X, Y, and Z were the exact same things that got them in front of me, how would that happen at the company? And the answer usually was the exact same way it happened 3 years ago, which caused this entire problem. And that's a failure of the council, of course, but that's a failure of the company to really think, why did this happen? How do we prevent it from happening again? And it can't just be, we're going to train our employees better. It has to be harder to engage in the fraud than it was before. And I think the final thing is something I talked about a little while ago, the failure to document. So the compliance officers are incredibly hardworking people. They work thousands of hours every year, and they don't write down what they did. I tell companies to follow the "what if I got hit by a bus" rule, which is, you can't come back to an investigation 7 years after the fact and go to the compliance officer or someone and say, well, what did you do to fix it? And the compliance officer has to remember, because the compliance officer will have worked, another 14,000 hours between the date you're doing your investigation and the date that he or she fixed the problem. And you need to have documentation. I've been in the room with SEC attorneys who literally say, if it's not written down, it didn't happen. And I don't like that formulation necessarily of things, but it is one that the government follows on a fairly regular basis. And so you need contemporaneous evidence of how you fix things. I think this is where your question about how compliance programs are different across the world, it's really idiosyncratic to companies and where they're based and how forward-leaning those jurisdictions are in compliance. So if you have a US-based company, I think that you see a promulgation of US-based standards across the world, which is really good. There are other countries that are sort of picking up that same thing. Spain has a compliance statute now, and France has Cestaro, which has compliance elements to it. And you'll see that companies that operate in those places will come up to those standards. I think you also see cultural differences amongst compliance programs and the risks that they face. So if I am doing a compliance project in Germany, I am much more likely to hear someone say, that was not part of my job. So there are cultural aspects to just how you work in general. And I think that everyone has to be really specifically attuned, and that's part of your risk profile, to those cultural differences in how you approach compliance. And I think that's where, someone who's worked across the world is bringing them in is very helpful.
Oh, that's very interesting. We had some recent cases in Brazil with some big Brazilian companies, for example, paying bribes in a regular way to public officials. So one point that you said, I believe this is very important. What a lot of these companies made later settlements. But one point, what the company made to avoid this kind of risks, the thing to happen again, I believe that's the main point in our answer, right, Steve?
That's right. Assessing that is absolutely critical.
Okay, Chris. I have another question here about the DOJ compliance guidance. The DOJ has issued guidance on how it evaluates a company compliance program. Why did DOJ do that? And what are the key takeaways, in your opinion?
So during my time at the Department of Justice, there was a real effort to try to be more transparent about how we thought about different things. And one of those things was how we evaluated corporate compliance programs. right? The DOJ and the FCPA unit, when there's an investigation and a potential resolution in a case, when a company has been engaged in bribery conduct, the DOJ prosecutors will be evaluating that company's compliance program to make a number of different decisions. It'll have an influence on the form of the resolution with the company. It'll have an influence on the penalties that the company pays, and it'll have an influence on whether or not the company gets a monitor as part of its resolution, where an independent party will be assessing that company's program over the course of approximately 3 years. And so DOJ, it was decided that we would make public, how we thought about that evaluation, and the aptly named evaluation of a corporate compliance program document was issued and is publicly available on the DOJ fraud section website. And what it does is provide the framework of how that assessment is made, as well as many of the questions that prosecutors would ask, compliance counsel and company counsel in the meetings when they were assessing a company's compliance program. And so if you're working an executive at a company or working for a company or a compliance professional, I really do think it makes sense to take a look at that document and think about your program through that lens. I do think it's helpful. As far as the takeaways, there's many. One I'd say is kind of the framework itself, that the document lays out 3 framework questions of whether the program's well designed, whether the program is adequately resourced and empowered, and whether effectively the program is tested. And then there's a whole bunch of sub-questions that go into each of those 3 framework questions. And I think a key takeaway is that all 3 of those things are necessary to have an effective program. It's important that the program is well designed, right? That you have all the right policies, but also that you've done a risk assessment and you've geared your program towards the risk profile of your business, and you're directing your resources in compliance towards the highest risks. So being well designed is critical. Being adequately resourced and empowered is also critical. If you don't have the people or the resources to actually do the job, of course you're set up to fail. If your program is not empowered, if you catch an issue or you identify potential misconduct, and your program, your compliance function is not empowered to stop that transaction from going forward, then it's not going to be successful, obviously. And the last piece that I think many companies struggle with is just the testing piece. That you're evaluating your program, you're auditing your program, you're looking to see is every third party getting through due diligence and have none been rejected? How are we constantly updating our program as our risk profile changes? Are we conducting investigations and not only identifying whether misconduct occurred, but also remediating that misconduct? All 3 of those key parts, I think, are critical in order to have a successful program. And the last thing I'd say is just third-party risk is so massive. You see in almost all of these corporate resolutions in the anti-bribery space with the FCPA unit, not all of them, but the large, massive majority of them involve third parties in the chain of the misconduct. And so assessing your third-party risk, making sure you're focusing on your due diligence, as well as you're continually monitoring the highest risk third parties, is just so critical to have a successful program.
Thank you, Chris. Our time is approaching the end. I'll make just some last questions for you all. Maria, I know this is that's something that could be the subject of a meeting or a new conference. But could you say a word to us about the whistleblower programs in the United States?
Sure, you're absolutely right. I mean, that's a full day conference in and of itself. I mean, I think most of all, the key thing to focus on is that in the US, generally speaking, whistleblowing is deeply entrenched in our investigative culture, right? It's rewarded as part of our criminal justice system and incentivized, especially important in cases like the Fcpa or other kind of intent-based crimes, where understanding what the participants in that criminal activity knew and intended, it's an incredibly difficult challenge to try to navigate. And, you know, having whistleblowers or cooperators who can shed light on those factors of an investigation that are so critically important to prove are hugely helpful. And there are a number of different and comprehensive rules that provide whistleblower protections, and a real pioneer system for providing not just cooperation credit, which is the kind of traditional sense where someone who is implicated in a scheme may get the benefit of reduced penalties or consequences, but rather a proactive financial incentive and whistleblower system that compensates people, whether they're involved in the scheme or not, for coming forward with information that can successfully lead to prosecutions. And we've seen a very significant uptick in the use of that whistleblower program and the impact that it's had. So specifically, just mentioning the Dodd-Frank Act, which was amended in 2010, affords a whistleblower who voluntarily provides original information that leads to a successful SEC enforcement action. We've been focusing a lot on the DOJ because the three of us are all former DOJ prosecutors, but these work in tandem, right? Where there's original information that leads to a successful SEC enforcement action resulting in sanctions exceeding $1 million, gets a financial reward. And that amount varies from case to case. It ranges from 10 to about 30% of the collected monetary sanctions. Whistleblowers in the US can remain anonymous through most of that process, and it allows for a number of additional anti-retaliation protections. And it's important because as we see, and we've talked about throughout, kind of global multi-jurisdictional cooperative enforcement trends, that's not necessarily true, right? This welcoming of whistleblowers and certainly a formalized process and program through which whistleblowers can be financially compensated is very novel in many other jurisdictions where whistleblowing can be taboo, and has certain cultural implications and limitations. But as I understand it, that legal framework is evolving even in other jurisdictions to improve the protections, to incentivize voluntary reporting, maybe not to the extent that Dodd-Frank does, but certainly we're seeing an increased reliance on whistleblowing awards and cooperation with other jurisdictions. Again, just in the interest of time, I'll stop there, but we could spend hours talking just about whistleblowing.
True. I believe here in Brazil it's also evolving, but we still have a long road to go. Anyway, it's an international trend maybe, or a best practice that I believe we should copy from United States, more protection and thinking about REARDs. We have I-Statute now that allows the payment of REARDs, but it still need more regulation. And talking about trends, Steve, could you give a word to us about trends in internal corporate investigation, and if the pandemic anyway affected it?
Sure. So look, the pandemic has affected it in two ways. The first is companies are just wildly different than they were. They have to sell through third parties more than they did because they can't put their salespeople out in the field. Deals are sort of upside down. More deals are make or break for a company because obviously income flow is not what it used to be, and supply chains are all messed up. So the risk is through the roof. And I think that's sort of the backdrop to our investigations. I would say the other thing is, heck of a lot more companies where I come in and they say, nobody's left from when this happened. And there's just a lot more turnover. And then I would say, the effect of a lot more turnover is there will be a lot more whistleblowers. So what Maria was just talking about. And so we see actually more internal investigations than I think we have seen in a long time in the past. And that could be because of President Biden is one thing. I think the department is not going to be more active necessarily, because I think the Trump department was very active, but the front office is probably going to be predisposed to more draconian penalties and monitors. And so people have to react to that reality. And then you just have all these whistleblowers kind of coming out of the woods. I would say the other thing is we've gotten a lot better at doing things remotely. And so that's tough for key interviews, I would say, is kind of the one place where that is hard. But as forensic accountants, for instance, we do not deploy to the field as much as we used to. We're willing to, but clients are understandably reluctant to do that. And if we don't need to, it's expensive for us to do it anyway. And so I think that will permanently change internal investigations in some ways. And I think that's a good thing. I think that we can be much more efficient if we don't have to spend time traveling and we can still do our work. But I would say that the big caution I have for companies, and we talk about this regularly, is just because everyone's gone doesn't mean you don't have to figure it out. And this is where, the law firms looking at contemporaneous documents will be more critical, and bringing in someone to pull out your accounting system and all the other data to make sure that the lawyers on the case have full information will also be important. And I think it's regrettable that you're not going to be able to close out with some of those investigative interviews, but you still have to figure out what happened.
Thank you, Steve. That has been a great conversation. I believe we could spend all day here talking, but unfortunately, our time is getting to the end. The idea was to have this opportunity to speak more about international and United States practice on internal corporate investigation. Talking about my experience, we know that we in Brazil have a lot of questions about it, and we still need to develop better our legal practice. And so we could learn and make some comparisons about the United States practice. I would like to thank all of you for the conversation in this morning. I'm pretty sure that the audience love it. Maybe we need to repeat this with more time with the patience of Laura Parente. But I really believe that was great. So thank you, Steve, Chris, Maria, and Laura for this opportunity. I'm sure that we could do this again in the near future.
Okay, thank you, Moro. Thank you all. I hope you see you in personal in some day, in some point. The webinars are great. We are produce a lot of content, but we miss interaction a lot. So I think everybody miss interaction. So thank you very much. This video is gonna keep on YouTube. So if you miss or if you want to share with friends, the video is gonna keep at the arbitration channel like the other videos you already made. Thank you all. Have a nice day. Be safe. Bye-bye.